Let me describe just briefly some of the allegations in the complaint. And at this juncture, what we have are allegations in the complaint. The lead plaintiff, Binyan Mohammed, was a 28-year-old Ethiopian citizen and a UK resident. He was arrested in Pakistan on immigration charges, flown to Morocco, placed in the custody of the Moroccan security officials, where he was subjected to routine beatings, suffered many broken bones. He was cut with a scalpel all over his body, including his penis. Hot stinging liquid was poured into his wounds, and he was blindfolded and handcuffed, subjected to extremely loud music day and night. After 18 months in Moroccan custody, he was then returned to American custody, and American officials then transferred him to Afghanistan, where he was detained in a CIA dark prison, where he was subjected to the recorded screams of women and children for 24 hours a day, 7 days a week. He was held there and starved, lost 40 to 60 pounds over the course of 4 months, sent to Guantanamo, where he languished for 5 years, and then was ultimately released and returned to the UK. There are several other plaintiffs. Their stories are very similar. I won't belabor the details. What happened in this case was that we brought tort claims against a private company, Jeppesen Data Plan. According to the allegations of the complaint, Jeppesen provided flight and logistical support to the aircraft and crew that were involved in the transfer of these prisoners from one country to another by American officials. It was a claim under the claims under the Alien Tort Statute by private individuals against a private entity. The United States government intervened on behalf of the defendant and brought a motion to dismiss. So I'm not sure where you are in civil procedure. This was at the pleading stage. It was a motion to dismiss the complaint such that the case should not even go forward, no discovery should be conducted. The government said, state secrets. This case is all about state secrets, notwithstanding the fact that, in fact, there was ample evidence actually in the public record, in press accounts that had come to light, in FOIA litigation records that had come to light, and on which the plaintiffs could have established their claims. The government said, no, here's a classified declaration from the director of the CIA. You have to dismiss this. It's a state secret. It's a state secret. The district court granted the motion to dismiss and said, yep, case can't go forward. Went up to the Ninth Circuit. And the case was fully briefed under the Bush administration, and then it was set for oral argument on February 9th, 2009. Well, what happened in January 2009? Obama was inaugurated. So at the panel, in front of the three-judge panel, it was quite amusing almost. The panel kept on saying, so is this still your position? And the new Obama Justice Department adhered as vigorously as ever to the old Bush position, motion to dismiss, state secrets, this should not proceed past the motion to dismiss, past the pleading stage. Shortly thereafter, in April 2009, the three-judge panel reversed the district court and said, no state secret defense. Later that year in September, the Attorney General Holder issued a memo outlining the circumstances under which the Obama administration would invoke the state secrets defense, and I'll talk about that in a second. Then the case was taken up en banc by the Ninth Circuit, and the full en banc court upheld the decision, affirmed the decision of the district court to dismiss, although on somewhat different grounds. So before I talk about the majority's decision, just a brief background in the state secrets doctrine. Basically, the state secrets doctrine comprises basically two somewhat conceptually distinct legal doctrines. First, there is what's known as the Totten bar. That is a bar to adjudication. Case cannot even be considered, and then there's a lot of debate about when the case cannot be considered. In its largest iteration, the Totten bar bars adjudication of any case where the very subject matter of the action is a state secret. There are other ways to construe the Totten bar more narrowly, and that was one of the issues being disputed by the en banc majority in dissent. Totten itself was a Civil War case in which the estate of a spy sued the US government saying, there was this guy who was a spy, and he had a contract with you for spying services, espionage services, and you didn't pay, so pay up. And the Supreme Court said, no, this is a state secret because the very subject matter of the action is a state secret. We can't go forward and adjudicate this breach of contract claim. There was a similar case in the Cold War, Tenet v. Doe. Again, two Cold War spies said, hey, we had an agreement, you didn't pay up. And the court said, no, this is just like Totten. There was one other application of the Totten bar, which wasn't a spying agreement, but it was a suit by environmentalists against the NEPA, the National Environmental Protection Act, to compel the Navy to prepare an environmental impact report on a Navy facility that was alleged to be using to store nuclear weapons. And the court said, well, if they prepare an EIR, they'd have to admit or deny that nukes are actually being stored there, so state secrets can't go forward. So Totten, that's one iteration, that's one aspect of the doctrine. The other state secrets doctrine is an evidentiary privilege. It is much more narrow. And it takes its name from the seminal case Reynolds, which involved, this was another Cold War case, 1953, involved a military aircraft alleged to be carrying secret stuff, crashed. 3 civilians, the estates of 3 civilians killed in the accident brought suit against the government saying, tort claim. And in discovery sought an Air Force investigation report which had been done after the accident and some various other things. The government said, no, state secret, we can't let this out because the investigation report might talk about all that secret spy stuff on the plane. And the Supreme Court said, yeah, that's right. There's a reasonable danger that disclosure of this the Air Force investigation report would reveal information about the secret electronic equipment on the plane, so you cannot have this in discovery. But under the Reynolds privilege, it is then up to the court. First the court decides whether the privilege is applicable, but then it decides, well, what do we do now? Maybe the litigation can go forward, but plaintiffs are just not able to use this evidence. If they can prove their case with something else, then yeah, go forward. So that's the Reynolds privilege. Now what the Ninth Circuit did in the Jefferson case, the majority said, we're not so sure the Totten bar applies here. Then they went on and said sort of unnecessarily broad things about the doctrine, but we're going to decide this case on the Reynolds privilege. And we think that even assuming the plaintiffs could prove the prima facie case of their tort claims under this voluminous public record, which substantiates many of the allegations in the complaint, we are still going to invoke the Reynolds privilege to A, preclude introduction of the evidence, but B, not prohibit the case from going forward even at the 12b6 stage, because basically there's no feasible way for Jefferson to raise any defenses without implicating something that's a state secret, i.e., is there or is there not an extraordinary rendition program? What are the details of the extraordinary rendition program? So we just don't think it can even go forward. We're really only invoking the evidentiary aspect of the state secrets doctrine, but we're going to use it at a very early stage in litigation to preclude any discovery. We're not even going to let discovery take shape to figure out how the evidentiary issues are going to arise in this specific litigation. We're just going to cut it off. 5 minutes, okay. So but then the majority said, okay, recognizing that they were doing something kind of bad, they sort of tried to make themselves feel better and say, we just want to mention, yes, we're invoking the Reynolds privilege at a very early stage, but after all, the government has assured us that they're only invoking the state secret defense consistent with what Attorney General Holder has now said are the government's guidelines for when they invoke it. And in this memo that Attorney General Holder wrote, he promised that the government's only really, we promise, going to invoke state secrets if in fact there really are national security risks here, and we promise we won't invoke it to conceal violations of the law, to conceal inefficiency, or to prevent embarrassment. So we promise, trust us.